to the rule of law and constitutionalism. Cognizance of the continued disregard of the Constitution of Kenya and the rule of law by elected and appointed leaders in this country, and in exercise of the sovereignty of the people of Kenya, given under Article 1 sub Article 2 of the Constitution of Kenya, which empowers you, the people of Kenya, to exercise sovereign power directly, the Law Society of Kenya shall lead the people of Kenya to occupy Parliament effective 12th of October 2020. Until a by-election is held, should the people's elected representatives in the 12th Parliament persist in impunity. Kenyans, this is the course that we must take here and now, because if we don't do that, our generation will be held accountable for the grave violations of the Constitution by our delegates. Thank you. Any questions? Sam, move a little bit closer.
Okay. You said that the advice of the Chief Justice cannot be challenged in court, but then every Kenyan has the right to go to court for interpretation of any decisions that may be affecting them or the state. So how do you reconcile that? And then secondly, you're saying that IBC should go ahead and conduct by elections after the resolution, but you are aware that currently they do not have a budget for such. In the intervening period, is anything possible because Parliament would be the house that has to look at these estimates and appropriate money for such an exercise?
Thank you, Sam. You've raised two fundamental questions. One, whether it is improper for us to assert that the decision of the Chief Justice cannot be challenged in a court of law, for the reason that every Kenyan is entitled to approach courts of law for reprieve. Every Kenyan expressed his or her will in the Constitution. Article 261 sub Article 7 contains the collective will of Kenyans. Unless and until the Constitution of Kenya is repealed, that represents the will of the people. And the government of the Republic of Kenya is constituted of a tripartite arrangement constituted of the legislature, the executive, and the judiciary. When performing this function to advise the president to dissolve parliament, the Chief Justice does not exercise the powers of a judge or administrative powers. He exercises delegated people's power. He is speaking to the President of the Republic of Kenya on behalf of the people of Kenya. And it's for that reason, therefore, that the people did not contemplate a situation whereby their will be challenged before a court of law. Number two, you've raised concern as to the ability of the IEBC to conduct a by-election for the reason that there is no money. Kenyans, your government, your elected and appointed people, have squandered close to 50 billion on account of COVID funds as we speak right now. What is the cost of conducting an election? Is it more than 10 billion? What is the cost of conducting a referendum? How much money, your money, has been allocated towards BBI? You see, there can never be the claim of inconvenience when you are required to comply with the Constitution. For that reason, therefore, IEBC should be prepared to hold a by-election at most within 90 days from the 12th of October. Kenya has money, a lot of money. Let that money not be pilfered. Let the money be used towards upholding the rule of law and constitutionalism.
But how is that money get to IBC? They need Parliament to fund it. And Parliament is saying to be dissolved beyond course of the
The only business that Parliament can do right now is to fund IBC. And this is not novel. They did that immediately before the election in 2017.
Patrick Lahat from the Daily Nation. Parliament has made two arguments in video before they advisory. One of them is that the court order done given by Justice John Masibo in 2017 was not served on them. One thing they say requires that there is evidence that that order was served on them. Speaker of the National Assembly. The second question related to that is they argue that order in 2017 relates to another parliament. How do you reconcile those two, given that this is the court?
Good. Lagat, from the Daily Nation, there is a principle in law that there must be an end to litigation. Parliamentarians are the lawmakers. They are the ones who made this law. There were two cases that preceded the decision by the Chief Justice. The first case was decided by Honorable Lady Justice Mumbi Ngugi, in which the National Assembly and the Senate, as well as the Attorney General, were parties. The second case was decided by Honorable Justice Mativo, again in which those three individuals were parties. The order was transmitted to them when it was delivered. How else would they have wanted the order to be transmitted to them? By registered mail? But more importantly, the Chief Justice, upon receiving a petition from Margaret Toili and David Sudi, did write to the speakers of the National Assembly and the Senate and asked them to explain what steps have been taken before he could act. The two speakers responded, and in fact, they sought more time. They therefore have knowledge of the making of this order. I seem to have forgotten your last question. Could you repeat it?
The 11th Parliament, the argument that the order
Okay.
the 11th Parliament.
Good. Parliament is parliament, just as government is government. We cannot say that we'll disregard all contracts that were entered into by the government under the leadership of President Mwai Kibaki, now that we have the leadership of President Uhuru Kenyatta. Parliament succeeds in perpetuity. Parliament has failed to comply. It is this parliament that is liable to be dissolved. That argument is unsustainable. In fact, the argument was raised before the Court of Appeal and it was dismissed by the Court of Appeal. This matter has reached its finality. Come a little bit closer.
What would be the fate of all the legislation passed by the 11th Parliament?
As we speak right now, Parliament is unconstitutional, but Parliament is yet to be dissolved. There is a time frame within which Parliament must be dissolved. That is 21 days from the 21st of September 2020. The 21 days lapse on the 12th of October 2020. Effective 12th October 2020, any laws that will be made by the National Assembly and the Senate will be null and void ab initio, because they will not have the propulsion, the sanction and support of the sovereign, the people of Kenya. Yes, sir. Come a little bit closer.
Okay. Does it concern you that the Chief Justice, in his what do you call it, advisory to the President, says that the speakers of the National Assembly and the Senate at some point didn't complete the correspondence, and so he stopped that engagement. And also the Attorney General never briefed on the status of pursuing the safeguard gender law. Yet the parliamentarians have been saying that there's a special interest bill before the Senate as well as a constitutional amendment bill. Does it concern you that the Chief Justice may have hurried to make that advisory, yet there are other matters that are going on which he may have looked for alternative information communication?
Parliament is a delegate of the people. Parliament must not beguile or lie to the people of Kenya. the special interest group bill has nothing whatsoever to do with gender parity and equality. Why do I say so? Because gender is predicated upon principles that are known, male and female. It's not an incapacity or a disadvantage. And to that end, both the Speaker of the National Assembly and the Senate have admitted their failure to comply. Why do I say so? Because two bills on two-third gender rule have been brought before the floor of the National Assembly, and they have failed because parliamentarians did not garner the required majority to pass the law. And if you look at it from that standpoint, you realize that the Chief Justice in fact bent backwards to accommodate Parliament and the Attorney General. But what did they do? The Chief Justice asked them to file replying affidavits to explain why there's been no compliance. They did file replying affidavits. They were also asked to put in written submissions, arguments on law. It will surprise you, Kenyans, despite the colossal sums of monies allocated to the National Assembly and the Senate, they did not respond. They did not proffer a legal argument before the Chief Justice. The only legal arguments that were before the Chief Justice were those put by the Law Society of Kenya. What about the Attorney General? The Attorney General did not even bother to respond to these petitions. He did not bother to write his submissions so that they can be considered. On what basis, therefore, will they be going to court? They have been given an opportunity to present their case. They did not present a case because they had no case. It cannot lie in their mouth right now to come and tell Kenyans that the Chief Justice has taken the country into a perilous path of turmoil. It is them, members of the National Assembly and the Senate, who have taken us to a perilous path. The Chief Justice has performed his role, and you, the people of Kenya, must stand firm and perform your role. Parliament must be dissolved pronto. Thank you, Kenyans. Perform your duty.
Sorry, what did you mean with occupy Parliament?
Yes, we meant that. We'll occupy Parliament because anybody who will be in Parliament in the name of our parliamentarians past the 12th of October will be a trespasser. He or she will not have the authority of the people of Kenya to legislate. We'll go there in accordance with the power given to us by the Constitution to exercise power directly and occupy Parliament until such a time as a by-election will have been held. We will not do what our friends in Burkina Faso did by setting ablaze Parliament, because we want these people out to put in better people in Parliament. No, we will not sit on the seats of Parliament. We will close Parliament to the trespassers. We will maintain vigil so that our property is not occupied by trespassers. Sam, are you satisfied? I've run out of breath.
But you can join us in the occupation.
Anybody?
You can join us in the occupation.
Oh, one more thing. The Law Society will conduct a national-wide campaign to be spearheaded by the branches to sensitize the people of Kenya on the need to do this. It must be done, Kenyans. May I therefore call upon the branch chairs to be prepared to undertake this noble task of asserting the will of the people of Kenya. Thank you. God bless you. God bless Kenya, now and forevermore.
Katanuk.
Ya, mtaka picha? Madam,